There's a real problem with the way small California employers think about workplace violence prevention. And getting it wrong jeopardizes both your employee safety and the financial health of the business you worked so hard to build. Based upon conversations with small business owners, here's what many of them are getting wrong. A policy isn't a plan. Many small California employers have workplace violence prevention policies, usually a paragraph or two long with a single focus, prohibiting employees from engaging in workplace violence. That doesn't meet California's requirements. A policy is one small element of a much larger prevention plan. A plan is a roadmap to safety. It's where you lay out specific steps to actively involve your employees in prevention, assess workplace safety hazards, remedy those hazards, investigate allegations of violence and threats of violence, train employees on the plan and on strategies to avoid physical harm, and annually evaluate how your plan is working. It's not who you think. Small business owners tend to associate workplace violence with current and former employees targeting other employees. That's not surprising. It's how media coverage has framed it since the 1970s. But according to the U.S. Department of Labor, coworker violence accounts for only about 25% of all workplace violence incidents. Most violent incidents come from people you invite onto your premises as part of doing business: customers, clients, patients, vendors, contractors. And for female employees specifically, a significant share of workplace violence stems from a current or former intimate partner. The financial threat you're not covered for. Because owners assume workplace violence means employee-on-employee incidents, they often assume that workers' comp covers the resulting costs. It doesn't. Not for the biggest risk. Third-party lawsuits get filed when someone you've invited onto your premises is attacked, whether by another invitee, a member of the public there to commit a crime, or one of your own employees. I've helped plaintiff attorneys bring 6- and 7-figure cases against employers over exactly this. Workers' comp doesn't touch it, and if an employee caused the harm, your general liability policy may carry an intentional tort exclusion, leaving you to pay for the legal fees in any settlement or jury award yourself. The financial fallout compounds from there. Higher employee turnover and absenteeism driving up labor costs and cutting into productivity. Lost revenue as customers take their business elsewhere. Your own time pulled away from running the business and into managing the aftermath. Why de-escalation training isn't enough. Most violent attacks happen without warning. A surprise attack, not two people threatening each other, then pushing and shoving, and then finally throwing punches. And yet, de-escalation is still the default training small employers reach for. Employees need to be able to recognize a threat before it turns violent with a range of tools they can match to the situation they're actually in, not just a script for talking someone down mid-confrontation. Generic training doesn't meet the bar. Many employers buy bundled online training, workplace violence lumped with sexual harassment and discrimination modules. It's cost-effective, but its one-size-fits-all doesn't meet California's requirements, especially the one for active employee involvement in choosing the training they feel best suits their actual situation. These packages often lean on run, hide, and fight active shooter training, even though, according to the Department of Justice, active shooter events make up less than 1% of all workplace violence incidents. Throughout the law, California's requirement is for specificity, training employees on the specific safety hazards they face and effective ways to address them. That has to be the focus of the training you provide. An incident report isn't an investigation. An incident report documents what happened. It doesn't dig into why it happened or use that information to prevent the next incident. California requires an actual investigation process, one that ensures employee involvement, protects participants, including witnesses, from retaliation, uses findings to inform both discipline and prevention, and feeds into a violent incident log. Most of these blind spots come from the way employers have traditionally thought about workplace violence. But those old assumptions don't meet California's requirements, and they leave your employees and your business more exposed, not less. If you'd like to see where you stand on implementing California's requirements and protecting your employees, schedule your free 15-minute California Compliance Safety Snapshot call.